Hi, everybody. I'm Geraldo Rivera. There was blood on the fence at Nicole's gate, and it came from O.J. Simpson. That explosive allegation today from prosecutors who revealed they had a plan to prove that the blood at the scene and on the socks had not been planted. Also today, a key defense witness has left the country, and A.C. Cowlings has a new phone number. Here's John Gibson at the courthouse with the latest. John.
A.C. Cowlings is now officially making a living off his friend O.J. Simpson. Cowlings' 900 number starts up today with Cowlings telling anecdotes about his life with Simpson and charging callers $2.99 per minute. However, Cowlings says he will not tell what happened in the Bronco the day of that slow-speed chase until he is called to testify. The other big news of the day, more evidence that places O.J. Simpson at the scene of the crime.
And that's close up.
O.J. Simpson's blood on the gate at the rear of the walkway to Nicole Simpson's condo. The prosecutor said had the defense known this a week ago, Johnny Cochran would have accused the police of planting that evidence too.
And had they known that that is Mr. Simpson's blood on the rear gate in Bundy, Mr. Cochran would have alleged that perhaps Van Atta went over there and sprinkled it on the gate at some later date.
After court, the defense said, hold on, these particular blood spots were retrieved 3 weeks after the murders.
So I think that there's a real question about contamination.
I totally believe in my friend's innocence.
Meanwhile, A.C. Cowlings, O.J. Simpson's lifelong friend, has launched a commercial enterprise to make money off his close relationship with Simpson. His lawyer says, why not?
I hope he does make some money on this. His friends hope that he makes some money on this.
Cowlings says he will not tell what was going on during the freeway chase last June 17th until he is called to testify. Back in court, Ron Phillips, one of the first 2 detectives at the murder scene.
Wearing a black dress.
Phillips is Mark Furman's partner. He testified that he and Furman wound up at O.J. Simpson's house helping 2 other detectives in their attempts to notify O.J. Simpson that his ex-wife was dead and that his children were at the West L.A. station. But instead, they saw blood at Simpson's property and decided to enter.
Detective Furman went over the wall of the Rockingham residence.
Later, Phillips will tell how Mark Furman brought him to see the bloody glove that Furman found on Simpson's property. And the Simpson defense team now says one of their key witnesses has left the country because she is afraid to testify. That is Rosa Lopez, who says she saw Simpson's Bronco at his house at the time of the murders. The Simpson defense wanted to call her to court, but now they're afraid they'll have to go to El Salvador to put her testimony on tape. And the judge says that he will or could allow that. John Gibson, NBC News, Los Angeles. Now back to you.
John, I've asked the fellows in the control room to dial AC's number, then put it on the PA system. I want to hear exactly what he has to say for $2 a minute, is it?
$2.99.
$2.99. Oh, $2.99. It better be good. It better be real good. Now, I understand that NBC News is reporting, or at least has reported, that Mark Furman was allegedly involved in some other murder case in which there was evidence tampered with or lost. What's the story?
NBC News learned today that there is a case that dates back to April of '94, a murder case in which Furman was one of the detectives. He retrieved some evidence in this case, which was a door, and it had a bullet in it. And he took the door apart to get the bullet and made a videotape of dismantling this door. But he never logged in the door as evidence, and he never logged in the videotape as evidence, and subsequently both items were lost. And because of this, because the evidence was lost, at least part of the reason this case was dismissed was because the evidence was lost. So it's not a good thing for Furman, and the defense may well use it to attack him.
I could see losing a videotape. A door would be would be difficult.
Door is a large item, yes.
All right, play the videotapes. I want to see Rock Harmon with his bombshell today. So let's run that, and then let's run the full Cochran response to what the DA today sprung on the defense. Let's see that right now.
There's simply no reason for the defense to interrupt our testing at this point in time, especially after they have formally made serious accusations about the sock, and had they known that that is Mr. Simpson's blood on the rear gate in Bundy, Mr. Cochran would have alleged that perhaps Van Atta went over there and sprinkled it on the gate at some later date. He just didn't know that because those test results were just made available recently to Dr. Blake.
We heard a statement apparently from Mr. Harmon this morning with regard to some results of some blood supposedly found on the back fence. What Mr. Harmon didn't bother to tell you was that although there's been testimony that this blood was allegedly pointed out to the detectives on June 13th, it was not picked up or retrieved until July 3rd, as I understand the evidence, fully 3 weeks later, after that scene had been hosed down, cleaned out, etc., with a number of people around there. So be a real question about whether that is contaminated or whether this evidence has any integrity whatsoever.
Now that John Cochran's statement about people walking around and looky-loos, I forget what else he said, that may ring true with the jury, but I don't think it's going to impress anyone who knows the science of blood testing. If it's Simpson's blood, it's Simpson's blood, whether it's taken the day of or 3 weeks later.
Well, there's a point, and this came up in the context of the judge ordering this prosecution evidence, these particular blood samples, to go through another test next Monday at the FBI, looking for a laboratory preservative, which is usually put in a blood sample to make sure that it is preserved for the testing. So what they want to do is test this stuff and see if this EPTA is in the blood or if it is not in the blood, because that might indicate just what Johnny Cochran is suggesting, that the police took a sample, then went back and planted it. If it has the preservative in it, then it becomes more of a viable question.
Okay, so everyone understands that. Now, they put some kind of preservative in blood once the sample is drawn and it goes to the lab. Presumably, if the cops planted the blood at Nicole's condo or on the sock or on the Bronco, the blood that would be splattered would have that lab preservative in it. If it doesn't have the lab preservative in it, then it is not, or presumably has not been planted there because it didn't go through the lab, and that's the only blood the cops ever had of OJ's. So the question becomes whether or not you can test for the absence of a preservative, and here it's another scientific question, and I'm sure that these guys are going to argue about this for a week or two.
Well, and there's also the question of what if the EPTA, the preservative, does show up, and Harmon is already saying, look, this stuff is in a lot of things. It's in clothes, it's in laundry, it's just around. So even if it does show up, we're going to litigate whether it was there before or separate from the blood. So, you know, it's going to be argued ad infinitum, whatever the result.
Okay, John, thanks. Have we gotten the AC calendar? Okay, get it. My crack team is efforting this, ladies and gentlemen. As soon as we get it, I'll let you know. Janine Ferris-Perot rejoins us, ladies and gentlemen, the fine district attorney of Westchester County, New York, former county judge. Ms. Perot is one of this area's top experts on domestic violence and child abuse. And before I leave you, it is now said that F. Lee Bailey will be cross-examining Detective Mark Furman. If you were Detective Mark Furman, would you be worrying?
Well, I certainly, if I were Detective Furman, I would be concerned about F. Lee Bailey. He makes a great impression. He's got a very strong position in the courtroom when he speaks. He's got a booming voice. But I think that if I were Mark Furman, I would also be grateful for the opportunity to finally be able to explain what it is that what I did and what it is that I said on the date in question. Because up to this point, there's been so much rumor and innuendo that he hasn't been able to respond to. He can finally respond.
So you think it'll be a relief as well as a trial?
I think absolutely it'll be a relief, and I think also it may be anticlimactic. I think people are expecting so much from this cross that there may be some disappointment for the defense.
I don't know. Stan Yeoman out on the coast, don't you think that the prosecution has done a fairly good job in de-escalating the significance, the importance of Mark Furman?
Well, yes, they have. I'm only concerned, if I was the prosecution, that they may be seen as trying to hide him. I mean, I could be wrong, but I thought one of the last things Marcia Clark said in court today was that the next witness was was going to be Detective Lang, that they weren't going to go to Mark Furman next. And that may be a clever decision. On the other hand, not having mentioned him during the opening statement, and if they wait too long to bring him on, it opens the door again for the defense to have an argument that they're trying to hide him.
Also, I was going to say...
Okay, here's John Burris, ladies and gentlemen. You know John Burris. He's a fellow who successfully represented Rodney King. He's a criminal defense and civil rights attorney, and a fine man there. We welcome him back.
Thank you. I think, though, that the prosecution, I think, has some problems and could have problems with a jury in terms of the jury's impression if this person isn't put on soon. He doesn't have to be put on next, but there is a sequence of events. You have his partner testifying now. You would think logically that he would testify next, and to not put him on, certainly from a jury's perspective, adds to Johnny Cochran's theory that there may be some effort to try to cover him because they're afraid of him, and they know they got to deal with this bombshell sooner or later, and that is his racist background and some of the things he may have done that cause him to question his credibility. So I think the prosecution may have a double-edged sword here if they continue to delay in putting him on.
But I think that the prosecution is doing a good job here, because what they're doing by putting on all these other witnesses is they're preempting the defense argument. They're establishing that Mark Furman was in a particular situation where he couldn't have had access to what the defense says he has access to, and the more witnesses who testify to that, the stronger it is for Furman when he takes a stand.
All right, let me take a break. Here's a question I want everyone to contemplate, all of our guests and you folks at home. Is it possible, now that the two key alibi witnesses, Rosa Lopez, gone to El Salvador, Marianne Gurgis, and we have her attorney live on the show tonight to talk about it, she being so severely impeached with these arrests and fraud charges. Is it possible that the defense, in its opening statement, has overpromised? Have they violated that cardinal rule never to do in an opening statement? Blood on the Gate is still our major focus. We'll be right back. And if we played it, you wouldn't spend the $2.99. So someone who's watching the show, spend that $2.99, call me back and tell me how you like it. Let me introduce William Grayson right now. We only have a couple of minutes in this short segment. Actually, I'm going to introduce him the way he introduces himself in his resume. I think it's really very telling. All right, he describes himself as a man who has handled death penalty murder cases, multi-kilo drug transaction cases, multi-million-dollar fraud cases, multiple-count sex cases, but most people remember him as the cop who represented Zsa Zsa Gabor when she slapped the cop as the lawyer who represented Zsa Zsa Gabor when she slapped the cop in Beverly Hills. Anyway, Bill, we really welcome you sincerely to our program for the first time in person. And as you know, ladies and gentlemen, he is now representing the controversial potential witness in the Simpson case, Marianne Gurgis. So, William Grayson, how is she holding up?
She's doing all right. She's nervous, she's upset, she's depressed, but her family and friends are supporting her. She's moved back in with her family. Every day she goes to work at her jewelry store. She keeps her appointments with her lawyers. And we've indicated to all the police and prosecutors that if they are interested in seeing her, they don't have to arrest her. She will go to any court that she's asked to go to.
Is it possible that she will have even more arrests? There are already 2 now pending against her.
Possible arrests, not likely. More charges, I think more charges will be coming.
Separate criminal actions in different jurisdictions?
Yes, she has a case in West Los Angeles. She has a case in another jurisdiction called West Covina. And there's a third case out there somewhere also. In the third case, I have not been able to get a hold of the district attorney investigator. He might be planning to arrest her at any minute. I do want to get a hold of him if he's listening to the program. I want him to know he doesn't need to arrest her again. She will go where asked.
Bill, is it at all possible that your client is, exactly as Marcia Clark described her, a pathological liar?
That is a real possibility. She's a logical suspect, at least in one case. I don't know about the others. But I do think that the investigation was prematurely brought to court. I don't mean the investigation. I mean the case was brought to court prematurely because she's a witness. And as to the second case she got arrested for, that didn't start until after she was announced as a witness.
But Bill, if you're citing to us several other cases, I only have a couple of seconds. I'll come back to you.
Sure.
Your client, aside from being a liar, sounds like a flake, with all due respect.
That remains to be seen, but like I say, she's a logical suspect for that, what you say.
She's a logical alleged flake. We'll be right back. Blood on the Gate, our focus. The rest of the show to follow.
We had actually been filing motions in court to ask for what we call a conditional examination, because we had received reports that this woman was fearful of coming to court because of media interference and other elements that might cause her not to want to testify.
Well, we'd like to have her back, but I mean, El Salvador's not a world away. The judge did say that we can go to El Salvador. She, I think, stands by what she says. She's just afraid of all the people coming at her. So this is a very important case. I mean, understand that if we all have to go to El Salvador, we'll do that.
John Burris, before I ask William Grayson the disingenuous question of whether or not he get paid in advance by Marianne Gurgis, I wonder if you believe that the alibi witnesses could be a real problem for the defense.
Well, I think Cochran's comment with respect to Rosa Lopez is a legitimate one. I don't think that she appears to be a flake in and of itself. I think she has some real concerns. Certainly, if I were the defense, I would have some concerns about his client here.
Marianne Gurgis.
Marianne Gurgis, just because her criminal history itself might be such that if any of it got before the jury, they would not believe anything she has to say, and thus they would place her in a disadvantage. If I were the defense, I certainly wouldn't put a lot of my case around this particular person. I do think that Rosa Lopez is important. It only seems to me that they can go there and take her testimony. That's not uncommon. It does happen from time to time. She obviously is going to be a critical person for them to create some reasonable doubt that the car hadn't been moved. But certainly from the defense point of view, they did, I think, promise too much. It's never wise to say all you have to say in opening statements. Less is best. And in this case, maybe they said too much. It may have been more for the jury, maybe more for the public persona. But in any event, it gives the prosecution much more to shoot at, which is never good for them.
I think that this is a classic example of what happens when the defense says that we will prove X, Y, and Z. Traditionally, a defense attorney in an opening statement will say, listen carefully to the evidence, attack the prosecution's evidence. But when the defense gets as specific as Johnny Cochran did in his opening statement, then he faces problems. And now they're in the middle of a mess because of Gurgis and Rosa Lopez. And now they're facing the consequences of being too specific.
Bill, your tone has changed a bit in the week since we spoke to you on the telephone. It does seem as if you are trying to distance yourself, at least somewhat, from the integrity or lack of it of your client.
When we last talked, I told you that I would be doing some investigation and looking into it and would know more about the case as the days went along, and I do know more about the case now than I did when we last spoke.
All right, let me specifically ask you the question I asked you that you seemed, for lawyer-like reasons, to be evasive. I asked you if Marianne Gurgis was indeed the person who stayed at the Marriott Hotel and ran up bills approaching $24,000. You said you didn't know. What's the answer as you sit there tonight?
She did stay at the hotel. She did pay some of her bill, but not all of it. We don't know how long she stayed or what she really owes. We don't know if it should be a part of the civil case that was filed last December or if it should be the criminal case, which only came to court after she became a O.J. Simpson witness.
Is she an O.J. Simpson case groupie, as the Marshall Clark suggested?
I've heard that said. I didn't ask her that. I didn't ask my client that question. I don't know if she's an O.J. Simpson groupie. Right now, she's pretty much concerned about her own problems with the law.
It sounds to me like she's that she's in a whole lot of trouble in a whole lot of different areas, and they can't all be because she's a witness in the Simpson case.
Some are, some aren't. Some of the investigations were brought early. Some of the investigations are only started because she's a witness. It doesn't make her innocent or guilty, the fact that she's an O.J. Simpson witness, or even the fact that she's being investigated by the DA. It doesn't make her innocent or guilty. It just is something to consider overall in the case, whether or not this is because she's a witness or because she actually did something against the law.
Stan, would you put her on the stand if you were Johnny Cochran or F. Lee Bailey?
Well, having promised her, they are in a tough spot. I mean, normally an awful lot is decided in opening statements. Studies show 80% of the jurors make their decisions there. But in a case like this, that may not be true because Mr. Cochran may not be able to fulfill his promises. As was said earlier, defense lawyers inevitably try to be very general because they're worried about what's going to happen, because very often defense witnesses turn out to be like this. You think you've got them, and then they sort of don't come forward with all that they promised. And that's the problem you've got here. He may have to put her on, or someone else, to suggest just someone fleeing from the scene, or else those jurors are going to wonder what's going on, and then just, well, the explanation is, you know, you can't pick your witnesses, ladies and gentlemen of the jury. All right, this witness may be a problem, but she was there, and it may not prove the case beyond a reasonable doubt, but perhaps it raises a reasonable doubt.
I don't think he has to put her on, though. I don't think, just because you make a statement from a defense point of view about what you intend the evidence to show, you're not obligated to do so. It's a little bit different than the prosecutor making some kind of commitment. After all, the defense can sit back and say the case has changed somewhat, that he really doesn't have to do all the things he promised to do in the beginning because the prosecution really hasn't proved their case. I think they play it smart, cross-examine in an effective way. They're not obligated to put this woman on, and given what I hear now, it might not be to their advantage. It's never wise to put a witness on that you know is going to get destroyed based upon her credibility.
Well, once again, you've got to remember, under California law, there's a real significant chance that unless she's convicted of one of these crimes by the time she testifies, it's really possible the jury may never hear about them. Unlike federal law, in California, at least by statute and the present case law, you have to be convicted of these kinds of crimes before they can be used against you.
You want to bet me a quarter, Stan, that she pleads to, gets all these cases consolidated, pleads to some reduced charge well before the need to testify?
You'd have to give me odds before I take that one.
I don't think that has to occur.
I'll bet the quarter, Geraldo, because she may be called if she is going to be called to testify at all, it'll be well before her cases are resolved. Right now, we're at a very early stage. Also, you should keep in mind she's not convicted of any misdemeanor or felony. If she is put on the stand, the prosecution could try to impeach her with her past acts of misconduct. Those would have to go before the judge first. He would have to decide what would come in, what would come in, what would not come in. And also, it would be, the jury would hear this, but remember, my client hasn't asked for any money or sold a story. What effect does it have on what she saw on that night in relation to whether or not she paid her bill at the Marriott?
Okay. Well, would you put her on the stand?
Would I?
Would I? Absolutely. I think that I agree with John. The defense doesn't have an obligation to put her on the stand. But what's at stake here is credibility. When the defense comes forward and says, we have two key witnesses, and they will prove that O.J. Simpson was not the person who committed the murders, they've got an obligation to put her on the stand. And then in closing argument simply say, we don't pick our witnesses.
But can you imagine why people hate the justice system if it is impossible to mention that this woman now has 4 or 5 arrests pending against her? Then you understand why people don't believe in what happens in the courtroom.
You know,
it's so artificial. Right back. Sorry, got to take a break.
In business.
Before you entered through the rear gate, sir, was anything pointed out to you to be careful of?
Well, I was pointed out some blood that was on the top rung of the rear gate, and also on the bottom rung of the rear gate, and then also at a latch on the rear gate.
Okay. And so, did you touch the gate?
No, I did not.
And was there any other blood pointed out to you near that area of the rear gate?
I believe there was another drop of blood or two in the vicinity of that rear gate.
On the ground?
On the ground.
Detective Ron Phillips, blood, ladies and gentlemen, that out of the hearing of the jury, a district attorney named, what's his name? Not Rockney. Rockney Harmon, that's right. Rockney Harmon saying that blood now has been tested for DNA testing, and the blood comes back as O.J. Simpson's. And I wonder, John Burris, if you believe that the defense has overpromised this conspiracy theory. If all this blood is coming back and it's Simpsons and Simpsons and Simpsons, don't they have quite a burden on their hands, affirmative burden, to prove that the cops put it there?
Well, I certainly believe that telling the prosecution at the outset that you were going to prove that this blood was contaminated, corrupted, and compromised was not a strategy that I would normally employ. Now, unfortunately, you have to go through each individual witness and try to show somehow that there was some nefarious activity on the part of each officer. That's actually a very difficult burden and something that they're going to struggle with as they go forward. On this issue of the blood that was found today, I don't know that it's totally outside of the realm of what they've been saying before, in as much as the blood was not removed for 3 weeks or more. That's entirely consistent with the rest of their theory. I'm not certain that theory is going to prevail, but certainly to the extent that other blood has been, other tests were performed at subsequent points, and the argument is it's contaminated, this is consistent with that argument. I do think, though, telling everyone at the outset how you're going to do it, what you're going to do, in my view, is not necessarily a wise strategy on the part of defense lawyers.
Could the mere repetition, Janine, of the allegation or the insinuation that the cops are crooked and that the cops are corrupt and that the cops have corrupted the evidence. Just making the allegation, the inference, time and time again. Could it have an effect on this jury?
Absolutely. If you say something frequently enough, the jury will start to believe it, even though there's no basis. I mean, it's human nature. That's why attorneys do it, prosecutors as well as defense attorneys. But if this blood indeed is the defendant's blood, what we're seeing now is a case that's even more straightforward than we thought initially. There is blood evidence. There is really a lack of alibi. There are inconsistent statements. There's a motive here. There's a history of abuse. There are all kinds of pieces to this case, and it's becoming stronger and stronger. So what the defense has to do is try to say, well, there's corruption, there's conspiracy. And the more they say it, if the prosecution can come back and say there's no preservative in the blood that's on the gate, then it backfires on the defense.
And yet Stan Goldman, as effectively as the district attorney from Westchester County, has recited the prosecution case. There is nothing like that kind of cogency or logical presentation in that courtroom.
Well, yes. For the last couple of days, for example, when we listened to F. Lee Bailey cross-examine Sergeant Rossi, I didn't think Mr. Bailey made all that many points. He made a few, but boy, he sounded like he was making a lot of points. And there may be two separate trials going on here. One, the substance that lawyers can sit back and analyze and say, you know, that wasn't that big a deal. The other is the way it sounds to jurors who are listening to this and saying, my gosh, Mr. Bailey really made this guy sound like he didn't do his job, he didn't protect the scene, all sorts of things were corrupted and changed at the scene. How do we know we can believe any of this evidence? So you have to take all the rational evidence presented in this case with a bit of a grain of salt, given the presentation by the lawyers.
He's certainly putting the prosecution on the defensive because he does raise questions and insinuate certain kinds of facts from those questions that immediately puts the prosecution on guard.
But John, I want to ask you a question. I want you, now I know you're a great attorney, you've been there in these trenches, you understand the volatility of the race issue in Los Angeles. I want you to cite for me one telling point, substantive point, that F. Lee Bailey made over the course of his cross-examination in the last several days.
Well, I don't know that he made one substantive point. I think it was a question of small points that he was trying to make that set up the next witness and the witness thereafter. Effective cross-examination, even though it might appear to be blustery on his face, doesn't necessarily have to have a telling blow to be effective. And I think that he was trying to show that certain things weren't done over a period of time, that if you look at them in the totality, when you see other witnesses, it might suggest that the police officers were engaged in a conduct that was designed to get O.J. But in terms of one particular telling moment, I certainly didn't see it. I have to agree with Stan on that point.
But there's also another piece to this. I think the fact that that F. Lee Bailey has this booming voice and that he basically takes control of the courtroom is something that the jury will become accustomed to. They'll become accustomed to the same questions. It's almost like saying to the nurse, you know, why didn't you do this kind of surgery? Well, if it's not that police officer's job, then we can't expect the officer to do what another officer is supposed to do.
I'd agree completely if F. Lee Bailey were the only lawyer in this case, but luckily there are four who are going to be doing the cross-examination. I got to tell you, he would grate on my nerves if he went on 6 months like this. But if he does every fourth witness, he may very well still have some potential impact with the jurors.
But the question is, do blunders or incompetence or the whole it's not my job kind of philosophy, does that add up to conspiracy in the mind of even the most suspicious juror?
It adds up to conspiracy if you're predisposed to want to find a conspiracy and predisposed to want to find O.J. Simpson not guilty. If those jurors began this case and finished the opening statements wanting to find O.J. Simpson not guilty, they will try to fit in all these little points into the theory and say, well, those are big gaps. That's reasonable doubt. If they didn't want to, it's a matter of psychology here in terms of how these jurors are approaching this evidence, what they're filtering in and what they're filtering out at this point. We don't have any way of knowing it.
I really think they have a problem when you try to run the conspiracy theory out on one argument, and then at the same time you're trying to run the competency question out. And does at some point in time the incompetency of officers in fact prove the conspiracy in a backhanded sort of way? When you don't have direct activity of a conspiracy, but you have so much other failure to perform certain activity that you sort of back into it, and then you have one overt act that they're trying to prove with respect to Furman, that somehow you can convince a jury in that regard. But
you know, John, I see it cutting the other way. How could they be so sly, devious, and conspiratorial on the one hand. On the other hand, they can't even tie their shoes right.
This is the conflict they have. It's a real conflict I think they have in terms of the approach that they are applying here, because it's very difficult to run out a trick, real substantial conspiracy, but on the other hand, indicate that people were incompetent and they failed to do certain kinds of things, which I think they're going to do when they bring on some of their experts as it relates to the crime scene.
Becky from North Carolina, you're on the air, Becky.
Hi, Geraldo.
Hi.
Watch your show every night.
Thank you.
I was wanting to talk about F. Lee Bailey. I think he comes across as arrogant. He sounds mean-spirited, and I think he browbeats that poor Mr. Rossi. And if I was on the jury, I don't think I'd like that.
Well, that's an interesting point. Rossi is Stan Goldman, a kind of, let me go to Bill Grayson on this. Rossi, Sergeant Rossi, the supervisor, a very small voice, a kind of, I don't know, not a very charismatic fellow, nice guy. I bet he's a great dad. Do you think that Bailey came across as a bully, or do you think he just made Rossi shrink in his seat?
I think both. I think it did bully him a bit. I think Rossi did shrink. But either way, it works. What the defense is working for is to give the jury some reasonable doubt, whether it's good or bad, whether they hate Bailey or don't hate Bailey. Bailey's working hard to give that jury something to find O.J. Simpson not guilty on.
Okay, but now we saw Carl Douglas's cross-examination of Ron Shipp. It had almost a nasty tone. Which of the gentlemen was more effective, if either?
I think that probably F. Lee Bailey was more effective. I think he's got more control of the courtroom. It's clear that this man is someone who's been in a courtroom before. But I think there's also something when you talk about the conspiracy issue. It's like fighting fog. This jury may be predisposed to believe that maybe there was a conspiracy. But unless somebody gives this jury facts which indicate that this was done and that was done, they're going to have to decide this case on the evidence. And the evidence is very solid in terms of blood, forensic evidence, and admission evidence as well.
Unless the cops put it there.
Unless the cops, but you have to put some evidence in front of a jury to say they did it, not they could have done it or they would have done it.
Not that they wanted
to do it. You have to be that direct. You don't have to be that direct. You don't have to say definitively and prove definitively that an officer did certain kinds of things. You can basically circle the wagon. You can create sort of shadows that create the impression that the reasonable step, the next logical step, is that officer did certain things. They're not going to have to prove that there was an actual conspiracy in effect. All they really have to show is that the people, that there's some conduct that took place in this rush to judgment quarter theory that a jury could cause them to ponder and to back up and to look at this evidence in a more circumspect way. Trying to be definitive as a defense lawyer, affirmatively proving things, is a dangerous game, and it's one that you are apt not to win.
That's purely for Perry Mason. I've got to take a break. I want to leave the viewers with this reminder. F. Lee Bailey was fantastic in the Sam Shepard case. He got that Ohio doctor off basically because of prejudicial publicity. But remember, he was so bad in defending Patty Hearst, according to Patty Hearst, that the heiress used his incompetence as one of the reasons for her plea for clemency from the president. So Patty Hearst used Bailey's incompetence effectively, because she was ultimately got a presidential commutation of her sentence in the Simeonese Liberation Army case. So which Bailey showed up to the Simpson case? Well, I got to take a break. We'll be right back.
During that 45-minute period, have a legal duty to call the coroner?
Not as far as I know, no.
Did you know it was a misdemeanor to fail to call the coroner, Sergeant?
I don't believe it is, sir.
May I now approach the witness and show him the section?
I don't know what he's showing. Can I please see it, Your Honor?
Is that an objection for relevance? Sustained. Thank you.
Okay.
Sergeant Rossi, is it your job to take notes at a crime scene?
No, it's not.
Is it your job to notify the coroner?
No, it's not.
Is it your job to direct the investigation?
No, it is not.
Is it your job to call for a criminalist to appear?
No.
Is it your job to ask for a photographer to come?
No.
Is it your job to ask for a print expert to get there?
No.
Is it your job to direct the search at a crime scene?
No.
Or the collection of evidence?
No.
Are you trained in homicide investigation, sir?
No.
And so are you there to maintain the scene for the detective who is trained in homicide investigation?
That is correct.
Not bad, Marcia, but Stan Goldman, do you think they made a mistake in putting these cops on when the answer is no, 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 no?
Yes, I think in hindsight, which is always 20/20, they should have started with somebody like the detective who's on right now, or Lang, because these two officers really gave a great opening to the defense to say, I think Marcia Clark's redirect examination there was very poor. I think what she was basically saying is, you weren't trained to do this, you don't know anything about it. Well, the jury's sitting there going, well, why the heck was he there then? For 2 hours, these officers were in charge of the crime scene without any training or experience or the ability to really know what was right or wrong about preserving the evidence there. So I don't really know if it was good redirect examination, and I think they did make a mistake by putting them on. But let me just address one quick thing we had before the break, if I could. I think we've been saying for months on this case that the prosecution may have to prove this case far more stronger than they will have to prove almost any other case. Normally, they have to prove the case beyond a reasonable doubt. I think the prosecution has been convinced for months that they're going to have to prove the case against O.J. Simpson beyond any doubt. Now, I don't want the public, the viewers, thinking that all criminal cases have to be proven to the extent that the prosecution may have to prove this case. This is an unusual case because of who the defendant is and all the publicity surrounding it.
There's no question about it, Stan. I absolutely agree with you. The prosecution is faced with almost an impossible task here. They're dealing with the celebrity status of the defendant. They're dealing with so many rumors and innuendo and media coverage of this thing that, and now the issue of conspiracy that's hanging out there. The prosecution has a very, very difficult job here and a very big scale to tip.
John Burris, let me ask you this.
I don't think that's absolutely true.
Okay,
that's any different than they would have in any other case. I mean, the problem that they have in this case is exclusively a circumstantial evidence case, and they have LAPD, and in any case where circumstantial evidence and the police are part of the defense's strategy, you're going to have these kinds of attacks, and the case is not going to be any more or less difficult to prove, probably, other than the fact that you have the jury composition that you have, and we've discussed that on other cases. But I don't know that the burden necessarily is increased significantly. The evidence itself is not going to, it's going to be evidence that can be challenged, and if you can meet it, then you can meet it.
If I were Marcia Clark at the closing statement, I'd say not only would these cops have to have had a conspiracy to frame this guy and work in concert, in league, they had to know that nobody else would ever be caught and charged with the crime. They had to frame Simpson and know that someone else would never come forward.
Live conferencing and pre-recorded texts. I will share with the callers my life experiences with O.J. from my childhood through our NFL days, my close relationship with Nicole, and my views on the media. Callers will be able to leave messages and personal questions that they would like for me to address. Finally, I sincerely hope the truth and the reality to the public and to the press. I totally believe in my friend's innocence.
Janina, you going to rush out and dial that number?
I don't think so, but I'm waiting for you to dial it, and then you can tell all of us.
Stan, do you like it? A.C. Cowlings? His action?
You know, he's not going to say anything about the case. That's what his lawyer, Donald Ray, said today. And therefore, it probably doesn't have any impact on the case. The most that's going to happen is that if he says something there talking about some incidents in which he and O.J. Simpson were so close and did wonderful things for each other, and if he testifies favorably to the defense, prosecution might bring up some of those incidents they learn about from the call. I bet you the prosecution will be calling that every week, trying to find out what the new messages are. But for the most part, it's not going to have any impact on this trial unless he changes his mind and talks about what was said in the Bronco.
Do you think Chris Darden or Marcia Clark will leave a message on the items? Holly from Wisconsin, you're on the air. Holly, hi. Hello, Holly.
What I'm most curious about is Marcia Clark, when she's doing her, asking the questions, she goes over and over and over what she's asking. These people answer the questions, and then if F. Lee Bailey, he doesn't need to do this. Johnny Cochran doesn't need to do this. No one else needs to do this but her.
So you don't like that, Holly?
No, I think that's stupid.
Okay.
Well, the court could object. I mean, the defense lawyers could object that the question has been asked and answered. But I think that it's more of a sense that she feels that the defense is making more points and is making good points against her, and so she wants to go back and reiterate that those points are not to be accepted. And so she does that several times. It's not a bad technique if you can get away with it. And apparently the judge is not controlling her, nor are the defense lawyers objecting.
And remember that the burden of proof proof is on the prosecution here. Marcia Clark has to prove every element of this crime, so she has to be specific and she has to be clear to the jury.
Why wasn't she objecting more, Stan Goldman, during Bailey's cross-examination?
Well, she actually was objecting quite a bit, but, you know, she kept getting slapped down. I mean, I don't know whether Judge Ito has such deference for F. Lee Bailey that he was, I think there was at one stretch where she had something like 11 objections in a row rejected, and after a while, you just don't want to look bad in front of the jury. You keep, I mean, you may have noticed when there are breaks from sidebar conferences and she wins, for example, the defense objection is overruled, she will come back and the first thing she will say is, the objection was overruled, Your Honor, just to let the jurors know she won that one. I think she's nervous, I think she's tired, and I think she feels that perhaps the individual rulings are not going her way right now.
Frank, New York, you're on the air, Frank.
Yes.
Hi.
It appears that Bailey has his insidious way of belittling the police when he's cross-examining them.
True.
Is he going to score more points with this attitude?
John Burris?
Actually, I think that, you know, there's some danger with this consistent attack on every police officer who comes on the stand. You have to have a strategy for each individual witness, and the frontal assault on a witness doesn't necessarily pay off, particularly if that witness doesn't give you anything or demonstrates in any way that they have an axe to burn. And in that regard, I think that F. Lee Bailey, if he consistently did this on every witness, if Johnny Compton did on every witness, I think it would inure to their detriment. So I see your point. There were times I thought that his examination was a little too blustery, too much confrontational, but on other times I thought that he was doing a good job. You have to be ready to move and develop a different strategy with each witness, depending on how that witness responds to the question.
With the exception of Denise Brown's cross-examination by Robert Shapiro, as I recall, every single prosecution witness has been hammered.
Well, not hammered. No. Johnny Cochran did not hammer Risky and some of the other witnesses. It's a matter of style. You have a right to be aggressive and challenge, but that doesn't necessarily mean that you're confrontational or you disbelieve in everything they have to say. It's a matter of how you get at it.
Oh, let me get to the call. Thelma, Michigan. You're on the air, Thelma.
Thank you. Thank you. And I enjoy your show.
Thank you.
And I like to apologize right quick for what happened in your show about 3 weeks ago when the black lady was on there and they was giving you the business.
Reggie from Michigan. I'll never forget that call.
Okay. Well, all black people...
Hurt my feelings.
All black people are not the same. I don't believe
I know that, honey.
I don't believe in racing.